restrictive and prevented the enjoyment of the rights aforementioned, and that the alleged violation contravenes Article 52 of the Constitution of the Republic of Guinea-Bissau, the Universal Declaration of Human Rights, and the International Covenant on Civil and Political Rights. The applicant sought reliefs, including an order of the court condemning the respondents for violating his human rights, and order the respondents to pay him 3 billion CFA francs for the reparation for damage. He also sought the court to order that the applicant reassumes the function of Attorney General of the Republic because he was dismissed from his functions for the accomplishment of the deliberation of same. The respondents on their part submitted that the court lacks jurisdiction to entertain the matter and is not competent to entertain the reliefs sought in the application as they relate to the exercise of political powers of the respondents in imposing sanctions aimed at protecting national security interests, international law, and international peace and security. According to the respondents, sanctions imposed were both necessary and proportionate to the objective of stabilizing the political situation in Guinea-Bissau. The respondents also held that sanctions did not inflict unnecessary suffering on the applicant, nor did not cause greater harm than what was required to achieve the legitimate aim of ensuring effective and proper functioning of the institutions and sovereign organs of the state. That even individual rights were violated, as alleged by the applicant, same would be justified because where national security is threatened, human rights of those responsible take second place. The court, in its ruling, said considering the admissibility test, it must determine whether the parties before it are proper parties. According to the court, institutions of ECOWAS are not state parties to human rights instruments and therefore not the proper parties for an action of human rights violations. Only the member states that signed and ratified the instruments can be brought properly as respondents for human rights violations. The court said practicality of pursuing a claim for human rights violation against a community institution is not feasible simply because community institutions are not bound by the international or regional instruments that unpinned such claims.
We stay a while on this issue because the 11th external session of ECOWAS Court of Justice has ended in Accra with a call on member states to respect and implement the decisions of the courts. Ghana's Chief Justice, Justice Ininyabwa, speaking during the closing ceremony, also called for the strengthening of the court by expanding the membership of the judges. The external court session began on Monday, March 21, 2022, and this is the first for the country since its introduction in March 2007 in Mali. Court correspondent Barbara Kuma joins us on the phone line with more details from the closing ceremony. Barbara, if you can hear me, glad you could join us. It's been 11. Chief Justice Ininyabwa speaking during the closing ceremony also called for the strengthening of the court by expanding the membership.
that are supposed to be heard at the national level. Usually they defer those cases until they are heard from the national level. And if the need be, then they take it up from there. But they are not an appellate court to any of the national courts, and they are not in competition with any of the national courts. And so we can be rest assured that they are not going to be, they are not interfering and will not be interfering in any of the national courts, or issues that come up there should be dealt with by the national court.
Okay, Barakuma, very finally, you talked about original jurisdiction, and we heard from Godfred Dami, the Attorney General, that the courts, its original jurisdiction is to sit on cases including migration, trade tariffs, and